Welcome again, everyone, to a new episode of Makdisi Street. I'm joined, as always, by my brothers Sadi and Kareem, and we have an extraordinary guest today with us, Dr. Nimer Sultany. Nimer is a close friend, and he's a reader in public law at SOAS University of London. He's also the editor-in-chief of the Palestine Yearbook of International Law. He's been a human rights lawyer. He was involved in Mad al-Karmel in Palestine. He's also the author of many award-winning publications, including his book, Law and Revolution, Legitimacy and Constitutionalism After the Arab Spring, which was published in 2017. It honestly is a great honor to have Nimer with us. Nimer, welcome to our show. I guess the first question I want to ask you, or we want to ask you, is, since you are a professor of public law, and you've written so much about, as we discussed, human rights law, and you practiced as well as being an academic. The question we have is, given what's happening in Syria, and the overthrow of a hated regime, of a police state, and so on, what is your reaction, and how do you react as a scholar, as a person, as a Palestinian, to the invocation of law and justice in Syria, given the fact that at the same time the Israelis have invaded yet more Syrian territory? They've carried out the largest bombing campaign in their history of Syria after the overthrow of the Assad regime, and of course the complete Western disinterest in applying law or thinking about law and legality when it comes to Palestine. So what are your thoughts about that?
Well, obviously, on the one hand, the overthrow of the Assad regime is good news for all those victims who have suffered from the brutality of this regime over decades. And for one day, at least, it seemed like it's opening up the space for accountability after decades of impunity for this authoritarian regime and other authoritarian and autocratic regimes in the Middle East. Because the departure of the regime and the departure of the security forces that have sustained the regime, and the possibly the collapse of all the networks that have supported the regime, can open up the space for discontinuity or rupture from one regime to another. And this was basically the story of the Arab Spring, in which, to what extent the collapse of regimes led to rupture from previous practices, and what kind of continuities were maintained or reasserted themselves. And unfortunately, in many cases of the Arab Spring, we have seen the status quo reassert itself quite quickly. But on the other hand, Israel's actions show that impunity is also continuing. So if impunity for the Assad regime has, or possibly has ended, and there might be different forms of accountability for the regime's crimes against the Syrian people, the impunity of Israel is continuing through its actions against Syria. And if you look at these actions historically, what you see that, the landmark cases would be the 1967 war, the 1981 attack on Iraq, and now Syria. So if you look at least these three Israeli actions, what you see here is that they have always been couched in the language of defensive attacks or anticipatory attacks, while in fact they are preemptive aggressions. They are pure aggressions. So the 1967 war was based on a fabrication that Egypt was planning to attack, when both the US and Israel knew that was untrue, and actually were looking for a provocation against Syria in order to start the attack on Syria and Yemen, and gain territory by force. But over time, you see that even these fabrications are becoming even much more absurd, this kind of propaganda. So in 1981, they claimed that they wanted to prevent Iraq from gaining nuclear ability. And despite that, the UN Security Council unanimously, including the Reagan administration, said in a UN security resolution that Israel's action is a form of aggression, and Iraq is entitled to develop its own, technical abilities, as well as for a form of redress against Israel. And now what we see is that Israel is using these kind of flimsy, preemptive kind of defense arguments that convince no one, in order to control more territory, at least entrench the illegal occupation and unlawful annexation of the Golan Heights. Again, in 1981, the UN Security Council clearly stipulated that this is an unlawful annexation and it has no legal effect. It's not going to change the sovereignty over the territory, and that Syrian territorial integrity and political independence have to be respected. But they are using it, and there is a brazen Western support for that action. I was just looking at statements by the foreign minister in the UK, David Lammy, and this kind of support is precisely the reason why we have instability in the region, cynicism towards international law, and it's kind of magnifies everything that we have seen, at least since October 2023, in which the genocide was pretty much a Western one. And I was just asked recently about this idea of the region plagued with conflict. And there's this kind of meta-narrative of Western innocence in which conflict is seen as something internal, endogenous, as if there is no external interventions, there is no destruction of Iraq by the American and the British, and the mayhem that created in the region, including the creation of ISIS. There is no EU complicity in the disunity of governments in Palestine, including, and not many know this, the EU paid for over a decade for the bureaucrats of the Palestinian Authority, for the Fatah civil servants, to sit at home in Gaza, so they would undermine the newly elected Hamas government. So Hamas had to create the bureaucracy overnight. So, and then the EU, in addition to the US and Israel, of course, they opposed elections and they opposed a unity government between Ramallah and Gaza. So they are complicit in different ways. And the idea that, the blue-eyed white Ukrainians are, witnessing, are not used to conflict, while the Afghanis or the Iraqis or the Arabs are used to conflict, is simply kind of a Western fabrication, Western meta-narrative that absolves the West, given, the geopolitics of weak states in the global South, politically and economically. The rich Western countries are exerting their influence in ways that destabilize the region further, and they use that obviously to exploit resources. There's also the narrative of the West being supportive of human rights or pro-democracy, and obviously that is false in terms of their long-term popping up of autocratic regimes, because they know democracy in the region, including in Iran, means two things at least. One, the masses, the popular majorities, would want to control their own resources to the benefit of the people, not to be exploited by others for the profit of others. And secondly, popular majorities are against Israel because Israel is an apartheid regime, is an aggressor, is an expansionist state, and is committing genocide.
No, but on this point, could we just, of course, I mean, we agree with what you're saying. But the question is, in terms of, since we talked about Syria and the comparison with Palestine, I'm wondering, I mean, you've already indicated that the Israeli fabrication or excuse of defense or preemptive defense going into occupying yet more Syrian land, since they've already occupied the Golan for decades and decades, and now they're advancing into yet more Syrian territory, claiming that they want to create a buffer zone to protect the occupied zone that they already occupy illegally, etc. That's very clear. You're saying from an international perspective, it's against the law. But what do you say? I'm wondering what we say before we move to Palestine proper and the genocide in Gaza and the question of law. I'm wondering, what do you say to people who say, but yes, given all that, they acknowledge all this. So as you said, we acknowledge all this, but can there be like two forms of law working at the same time? In other words, justice in the case of Syria in a microcosm for those who have been victims of a police state versus and the attempt to sort of seek justice in the case of Syria, even if justice for Palestinians and law in terms of Israeli occupation of the Golan is bracketed? Can two things, you see what I'm saying? Can you have a micro or one aspect of law being enforced and one not? Is that, how do you react to that? People who say that you can't do everything.
Well, obviously, there's some truth in this, in the sense that German courts or even American courts were more willing to pursue legal tools such as universal jurisdiction in order to prosecute former Syrian security officials, for example, who are accused of torture. They haven't done so in the case of Israel. In the past, the problem was that there was a pursuit of people like al-Bashir of Sudan, but there is no pursuit by the International Criminal Court and also Western legal systems of Israeli officials. In fact, when a couple of decades ago there was an attempt to hold the Israelis to account, whether in Belgium for the Sabra Shatila massacres, or in universal jurisdiction in the UK against some officials. What happened is that under political pressure, the law was changed in order to prevent these attempts to hold the Israelis accountable. So I think the problem has always been that Israel in particular was kind of an extreme case of being above the law, of being not held with similar standards to others. I think the Western world is much more receptive, and you have seen their reactions to the overthrow of Assad. They are much more receptive to pursuing forms of accountability against some officials of the Syrian regime or other global South countries, but not Israel. I think one way to look at it, if you want to kind of assess the what we see as far as the effect of these events on international law, is that on the one hand, there's let's call it the view from below. If you look at international law and the Israeli legal system and the so-called post-World War II achievements of quote unquote humanity, the view from below is that this has not always been effective and it did not really exist for millions and millions of people. So if you are a Yemeni today, suffering from Saudi airstrikes supported by the UK, you don't really feel the existence of the effective international legal system. And the Palestinians, obviously, for decades have felt the same. Now, that does not mean that the international legal system did not exist, but rather that there has always been a kind of uneven enforcement, uneven application, and that the system itself had within it the seeds for its destruction. So the way it was designed, as you know, since World War II, is that there is a veto power for a handful of countries. And if you are the US and an ally of the US, you are likely to be above the law and you will not be held to account. Now, what's new is that in the last couple of decades or so, we have something called the ICC, the International Criminal Court, that are professionalized body that is relatively independent from the political will of states like the US. And hence we see these tensions in the last few years that mainly in the last few months, given the arrest warrants against Netanyahu and Gallant, that basically seek to destroy the semblance of the international legal orders that we had. So from the view of below, it has always been quite limited in its application, but more generally, it's true to say that whatever we had is being destroyed by Israel and the Western support for Israel.
Let me, if you can hear me, let me ask just a follow-up on this. So we're talking now, we're going to move to talk about the ICC and the case, the Palestine case, and see where we are and get your, since you've studied this extensively, just to, if you can tell us where we are in the ICC, just sort of explain maybe just very quickly the kind of legal background, and then try to, and then well, I have some questions after that, but if you can set up the case for us, and then we can go from there.
the International Criminal Court has been for over, since its establishment, have been accused rightly of being a tool in basically Western hands, because the kind of accused, the defendants they pursued, they were never from Western countries, despite the fact that many war crimes and crimes against humanity were committed by the likes of George W. Bush, for example. But these were not pursued, sometimes for technical reasons, when the U.S. Is not joining it. But when states commit crimes on the territory of states that have accepted the jurisdiction of the court, then they are liable to be pursued. And what we have seen in the last few years, that even in the case of the British crimes and American crimes in Iraq and Afghanistan, the ICC decided to discontinue the investigation, and they closed the file, claiming that there was some semblance of internal investigation, for example, in Britain. So there has always been a problem when it comes to the West or the allies of the West in the ICC. We had the prominent Palestinian human rights lawyer, Raji Sourani, the director of the Palestinian Center for Human Rights at SOAS University a while back. And when you hear the kind of heroic efforts that he and other Palestinian human rights organizations pursued in order to convince the ICC prosecutors of the need to take action, because what we have seen since then, that the fact that Israel was granted impunity emboldened it to commit even graver crimes, ultimately the crime of crimes, as it's called, genocide. And he says that the first prosecutor told the Palestinian human rights organizations that he is not going to defy American will. So even though the US is not part of the court, it was still exerting influence on the court. So, and we saw the Trump, when he was defying, in his first administration, was defying UN institutions, money that comes from the US is also can be influential. The institutional legitimacy and continuity of these institutions, the sanctions that the Trump administration had on particular officials. But more interestingly, what we have seen and revealed by The Guardian and other newspapers is that Israel has been pursuing covert and overt sabotage operations for a decade against the ICC and the ICC prosecutor in particular. So there has been a lot of foot dragging. There has been a lot of delay. There has been a lot of hesitation when it comes to the International Criminal Court and trying to hold individual Israeli leaders and military figures accountable. Now, eventually, faced with the gravity of what has been happening for all to see, and since October 2023, the ICC prosecutor, who shelved Palestine when he came into office, because there were obviously the apartheid question or allegation, and there is also the question of the settlements. There is an open file since 2021 when the International Criminal Court so-called pre-trial chamber, so the three judges who decided to open the case against Israel and to start the investigation, and that the ICC has a jurisdiction over Israeli crimes on Palestinian territory. Despite that, Karim Khan did not do any of that, and as Raji Sourani said, he didn't even meet with Palestinian organizations. And then after October, he decided to pursue this investigation. He did that after delay, and he did that in a very limited manner in terms of the choice of persons as well as the allegations against them. And then you all know how many months took to make the decisions. And in between, weird things happened, such as the chair of the panel, the Romanian judge, excused herself for unclear reasons. So we can only speculate what these reasons were. And the comparison between what happened in Russia and what happened in Israel is also kind of striking in terms of the double standards or the ways in which things move faster when these international institutions, and including the legal institutions, are faced with the enemies of the West, and how much slower and how much timid they are when it comes to Israel in particular as an ally of Western countries. But eventually they did issue arrest warrants, even more, slightly more limited than what was requested by the ICC prosecutor. Now, two words of caution. One, what we read from the ICC pre-trial chamber is a press release. So we don't know the full details of it. It might include more things than we know. Sometimes arrest warrants are issued, secretly, so we don't know. The ICC prosecutor said that before and after the decision by the court that it's an ongoing investigation and there will be more to come. So it remains to be seen what will happen next. But obviously, the very fact that they were issued is an earthquake, a very important decision.
Nimer, you're saying it's an earthquake. It's an earthquake in terms of the application of international law. Is that what you mean? So how do you reconcile that with what you said earlier, which is that the view from below is that international law is only applied to actors in the global south? And what you're saying now is that for the first time, at least I'm aware, maybe you can tell me if I'm wrong, for the first time an Israeli, quote, Western leader is indicted, and there's an arrest warrant out. Is this earthquake significant given the fact that the view from below, as you're saying, is biased? So can you explain what's the significance of this in a nutshell?
Well, I think it's an earthquake politically, first of all. So it's politically, it's one situation in which Nimer and Osama think that Netanyahu is a war criminal, and another situation in which, in addition to that, also these judges in the Supreme Court say that Netanyahu is a war criminal, that grave crimes have been committed, including the blockage and the denial of humanitarian aid and the crime of starvation. It's very important politically because it's important for political debates that include a lot of denial in terms of what Israel has been doing. It's also an earthquake kind of legally in the sense that they have attempted what has not been attempted so far. Now, it does not necessarily change the fact that the efficacy is still quite limited and might not materialize over a short term, because we have seen since then is that there's a kind of wall-to-wall support for Israel in the kind of richest and the most powerful Western countries, including the US and Germany and seemingly the UK, and potentially France, as we saw from the kind of convoluted reaction to the ICC warrants under, assume, Israeli and American pressure to be involved in Lebanon. So will they be effective in the sense, will they ever see a day in court? Will the victims of Netanyahu and Gallant and other Israeli war criminals will be able to see them held to account for their actions? We haven't seen that in other cases, like al-Bashir, for example. So with that kind of brazen support, and now with the Trump administration, the incoming administration, threatening even further sanctions, that's why I'm saying that what we are possibly seeing is the collapse of the whole international legal order and political order that was established since 1948, since World War II. And what we see here is that the contradictions of the system are being, foregrounded because of these ICC warrants. So these contradictions have always existed, but for the first time, this is sometimes is the benefit of legal actions, that you bring fire to the feet of these judges and let them decide and see whether they really follow their own talk about universal rights and the rule of law, or is it incoherent, inconsistent, and limited?
Nimer, just a question, follow-up. So just for the mechanics of this, right now the warrants were issued, and so who's supposed to? Can you just explain how the process works? Who's supposed to pick them up, and is this open-ended? Can you just explain so that, because we hear if they travel to country A or country B, then somebody can arrest them, but then we hear that France and even the Dutch kind of come and say, well, maybe, maybe not, we'll see, we won't see. Can you explain how that works and what the obligations of at least the member states that have signed on to this convention, what there are, and is there a way around it, or are they actually obliged to arrest him?
Well, I mean, there's currently 124 states that are members of the Rome Statute or the ICC, and all these states are supposed to apprehend Netanyahu and Gallant if they are on their territory and deliver them to the court in order for the legal proceedings to start. So this is the kind of the legal obligation on these states. And Mongolia recently was kind of reprimanded by the court because they didn't do that for Putin. Now, obviously, the Achilles heel of international law is that it's not self-enforcing. It requires cooperation from states. And if there is no cooperation from these states, or these states are under a lot of American pressure not to cooperate with the court, then again, that would be another way in which the whole idea of kind of a rule of law or international rule of law or a legal system in which crimes are punished will collapse. But what we have seen in cases like Putin is that his movement has been very limited, severely limited, because of the ICC warrants. Potentially, we will see the same. Now, we just saw Gallant in the US, but one of the issues that might arise is that en route to the US, Gallant or Netanyahu might potentially have an emergency landing because of flight conditions or weather conditions, let's say Spain. And then it will be an interesting legal question: what happens next? Will they be apprehended? Will they be delivered to the court or not? So now this is a test for all these states that were more than willing when it comes to al-Bashir or other cases and from the global south, or critical of states that did not do so when it comes to al-Bashir, whether they themselves will abide by the very legal system that they helped construct because of the lessons of World War II and the Holocaust.
Okay, so in short, if they're not caught, then they can't be tried at the ICC, correct? Like, they have to be taken physically to The Hague and tried. Otherwise, there could never be a trial in absentia. That's right. Okay, so can you just on a technical matter, can you just elaborate, because there's also some confusion. What exactly have they been charged with? Is it, there's some huge category of genocide, but what specifically have they been charged with? And can you also just mention the fact that the Palestinians, Hamas guys, have also had arrest warrants, although some have died, of course. But could you explain? I remember there were 3 Palestinians and 2 Israelis in the initial warrant. So if you can just explain that as well.
So I think, first of all, we need to understand there is a difference between the International Court of Justice and the International Criminal Court. So International Court of Justice, which is dealing with the question of genocide currently, is about state responsibility. It's not about individuals. International Criminal Court is now dealing with the individual criminal responsibility of individuals. Now, that can include genocide, obviously, because one of the crimes in the Rome Statute is genocide. But genocide was not one of those that, for now at least, was not included in the case of Netanyahu and Gallant. By the way, it was not included in the beginning in the case of al-Bashir, but then the court asked the prosecutor to add genocide. So in terms of the main crimes that they were accused of crimes that relate to starvation, and the targeted attacks on civilians and civilian infrastructure. And the systematic attacks on civilians is a crime against humanity. It's not only a war crime. Now, as you said correctly, in the beginning, the ICC prosecutor asked for 3 arrest warrants against Palestinians and then 2 against Israelis. And obviously, many of us have seen that as puzzling. First of all, it's puzzling because of the gravity of the Israeli actions and the enormity of these actions that are not really comparable to what happened on October 7th. That doesn't mean that there were no violations of the law on October 7th. It's just the gross asymmetry of power between a nuclear state, one of the strongest armies in the Middle East, and then what is essentially a densely populated, defenseless network of refugee camps in Gaza, has been, for all to see, and the numbers speak for themselves, and that the destruction speaks for itself. So, if the prosecutor decided to start the accusation against 3 in Hamas and then 2 in Israel, that was puzzling in terms of the numbers themselves. And it seemed like a kind of a political choice, because the prosecutor knew what is coming. So he was like trying to do a balancing act. And the inclusion of Haniyeh in particular was weird, because there is no evidence to suggest that Haniyeh was involved in October 7th. Haniyeh has been for a long time outside Gaza, and in a way it contributed to effectively justifying his assassination by Israel, because Israel had, from the beginning of or the aftermath of October 2023, have pursued his family, killing them, his children and his grandchildren, and bragging about it in TV as kind of a personal retribution against Haniyeh. And we know that the ICC, basically prosecutor, put a price on Haniyeh's head by including him in the arrest warrants. The lack of inclusion of other Israeli figures, despite all these crimes. So, for example, the Palestinian defendants or accused were accused because of torture and the treatment of hostages. But all of us have seen images on TV and on social media for a long time, the inhumane treatment of detainees by Israelis. And in the recent months, there has been a lot of information that has come out about the torture of these detainees, the overcrowded nature of prisons, the rape in some cases, the death of dozens of Palestinian detainees. So the fact that there was no charge with respect to torture and inhumane treatment and the crimes against the dignity of the Palestinians was weird. So that would implicate, for example, Ben Gvir was in charge of the Ministry of Internal Security, that is in charge of some of the prisons. It also implicates the military chief of staff, because some of these detention facilities are under the military. These systematic attacks that Netanyahu and Gallant are accused of can also be immediately attributed to the chief of staff of Israel.
So it's possible, Nimer, sorry, just to make sure we're understanding. So it's possible, at least in theory, that the net could be expanded to include these other characters as well, in addition to Netanyahu and Gallant, right?
Yeah, and the ICC prosecutor has
and the scope of charges too. Sorry, yeah.
Yeah, I think the ICC prosecutor has been suggested the same, so we'll see if he follows up. But I'm commenting here with respect to Karim's question about the initial decision to go for 3 plus 2, 3 Palestinians and 2 Israelis. that seemed like a political kind of both-sidism, in which and the exclusion of the apartheid allegation and the genocide allegation, I think, plays into the hands of this both-sidism, because it removes the context, the immediate context in which all these kind of violations of the law occur. So what we meet here is two sides who are committing crimes, and that's it, in kind of an armed conflict. But when it comes to things like apartheid and genocide, there's a clear asymmetry, because one side is imposing apartheid, one side is subjected to an apartheid, and one side is genociding the other side. So there's no clearer asymmetry than the genocide accusation. So when you remove these kind of structural and contextual kind of allegations, you get to the kind of more disparate or individualized notions. But obviously, international criminal law more generally is focusing on individuals rather than kind of the more structural or the contextual elements. But these can be rectified if further allegations against more Israeli leaders and Israeli military figures and more allegations against these leaders can be potentially rectified in order to make sure that the litany of war crimes and crimes against humanity and genocide that have been committed can be, the Israelis can be held accountable for them.
Nimer, just sorry, one last follow-up on this. Is it not true as well that all these people that are putting, all the Israeli soldiers that are putting things on TikTok and things like this, where they're showing their individual war crimes? I mean, just to clarify, this stuff is not necessarily for heads of state or leaders or heads of government. This is for any soldier, any individual can be accused and some kind of warrant issued, correct? And so, I mean, does the fact that all these TikTok, all these people that are incriminating themselves, can't this just be added to all these kinds of cases?
Yeah, obviously, I mean, the prosecutors and courts in this case, make decisions that reflect two things. One, the question of resources. So there will not be, there's no way that they will be pursuing, thousands and thousands of individual soldiers. And secondly, the question of responsibility. So Netanyahu and Gallant are pursued because they are responsible for decisions, for the conduct of their army, including. So, for example, when it comes to the question of genocide case, one of the issues that are being alleged by South Africa is that there's an incitement to genocide. So when you see incitement to genocide, and then Netanyahu and the government and the legal system is doing nothing about incitement to genocide, so that becomes in itself a violation of their legal duty to prevent incitement to genocide. So it's not only that them inciting to genocide or committing to genocide, but also their responsibility towards others. And the same with war crimes and crimes against humanity. There is, a well-known commander responsibility or command responsibility as well in international law. So the higher-ups are usually pursued because they are responsible for the violations by their units and as well as by the lower-ranking soldiers. Now, the fact that some of these soldiers are dual citizens and the fact that there is universal jurisdiction can allow not only, besides the International Criminal Court, it can allow multiple domestic legal systems to pursue these soldiers. So South Africa, for example, proclaimed a few months back that any South African who served in the army during the past year and committed crimes might be brought to justice in South Africa, and that can be the case in other cases. I heard about the case in the Netherlands, so we'll see how that materializes. But as I said, the ICC prosecutor went for the political leaders who are responsible. So it will remain to be seen if he goes then now to the military echelons, the chief of staff, and the main kind of generals in the army, because we have their statements, we know which units they were responsible for, and potentially the ICC prosecution can gather information and evidence about crimes that were committed under their command.
Nimer, just to be clear, we're going to move to the ICJ case now. But just to be clear and to follow up what Karim was asking you, it doesn't have to be the ICC, correct? It could be for individual soldiers who've committed, as Karim is saying, war crimes, and they've filled themselves on TikTok, and they end up in European or other countries, or other in Asia or anywhere else. Could they be prosecuted separate from the ICC, or do you need the universal jurisdiction, or how does that work?
As I
Just
said,
very briefly.
they are dual citizens. Then they can be prosecuted for, as any citizen.
What if they're not dual citizens?
If there is universal jurisdiction, they can, they are a tourist and the country has activated universal jurisdiction, it can pursue them potentially for war crimes.
I mean, for example, that Australian spokesman for the Israeli army or the Israeli state, there's a case against him in Australia, I believe. I forgot the guy's name, but right, that's outside the ICC framework. That's in Australian courts on the grounds of, I think, aiding and abetting genocide or something like that, because obviously it's against Australian law too.
Let's move to the ICJ case, because you've written in an essay, a recent essay called "The Threshold Crossed," which we'll link in the show description below. That quote, the court has failed to adequately reinforce and elucidate the obligation to prevent genocide. In other words, you're very critical of the fact that the court, has taken a very long time to move, and yet the ICJ. But a lot of us were thrilled at, or at least were following the ICJ case, and have, how do you explain to us the significance of the ICJ case as opposed to the ICC case?
Yeah, I mean, in order to understand the ICJ case, we need to go back to the moment in which South Africa submitted the application and the moment in which the ICJ in late January made the first provisional measures. Because, now we can be vulnerable to kind of revisionism, judging things a bit kind of retrospectively. Between October and the end of December, it was very hard for many of us to get a crack into the Western wall-to-wall support for Israel, whether it's the media, whether it's the academia, and whether it's the government. And then the South African application in December was a huge development. And as one Palestinian friend said, she said that for the first time I felt seen, because you read these 80 pages or so, and there is a story of what has Israel inflicted on the Palestinians since October in a comprehensive fashion. And that also led to opening up the academic space, the political space, the activism space, and even the legal space to discussion about the nature of Israel's campaign and whether it's genocide or not. And this, as you know, led also to various other debates about genocide in history and colonial genocide, and whether Israel and also Israel's policies themselves with respect to Palestinians historically. Because the narrative that we had till that application was that Israel was attacked in a surprising manner from some force external that crossed kind of international border, and unsuspectingly they were slaughtered. But the application said, no, there is 75 years of Nakba, there's 56 or 7 years of occupation, there's 75 years of an apartheid, there is 17 years of siege on the Gaza Strip that preceded all of that, in addition to obviously several highly disproportionate military campaigns that Israel waged on the Gaza Strip since the early 2000s. So that obviously shattered the idea that Gaza was not occupied and that Israel had no responsibility toward Gaza. And it also changed, I think, the global debate about Gaza. It emboldened student activists, it emboldened demonstrators in London and in other places. And it also allowed the conversation to shift a bit. The decision by the ICJ as well was a huge victory because it ordered a series of orders against Israel. First of all, it said that there's a risk of genocide, that there's a risk that Israel is committing a genocide, which was a huge blow to the kind of Western narrative about the war till then. And it was also a huge blow to those who dismissed the South African application to the court. And effectively, these decisions were about stopping the war, even though the court did not stop the war. Now, when courts like the ICJ issue rulings, they are immediately thrown into a field of interpretation. And there's a war of interpretation. How do you interpret them? And obviously, Israel and the US, in every single one of these three orders by the ICJ, they presented their own interpretation. And there is no reason for the rest of us to accept that interpretation, but rather we need to promote the more reasonable interpretation that actually fits the context and fits the text.
Very briefly, what is that? What is that interpretation? Very briefly, Nimer. What is that? The moral interpretation, the correct interpretation, as you put it.
Well, as we said at the time, I think many of us, that what the court has decided in January and also in March was effectively that Israel needs to stop the war, needs to stop the attack, because the only way, they said, to have an effective delivery of humanitarian aid is for the military action to discontinue. So for me, that was the main kind of, or should have been the main effect of these rulings. But Israel and the US said, well, first of all, Israel is not committing a genocide, so therefore it doesn't need, it's only military action. Therefore, it is abiding by these orders, because the orders are about telling Israel not to commit genocide, and they are not committing genocide. And of course, all the kind of propaganda about humanitarian aid throughout these months. But there was no reason for the rest of us to accept that interpretation, which obviously enabled Israel to kind of continue the attack on Gaza. But one problem is that you see in these cases, when you have 15 or 16 judges in the courts like the ICJ, all these decisions, eventually, the rulings, the way they are phrased, are the outcome of a negotiation between these judges, trying to generate as wide as consensus as they can. And that led to an ambiguity in some of the orders, in the operative parts of these provisional measures orders. And that ambiguity was obviously exploited by Israel and the US to further continue in the genocidal assault on Gaza. So in this sense, there is a sense of disappointment that the court was not able to reach kind of a consensus amongst many of the judges, or a majority of the judges, that will lead to a clearer stipulations with respect to Israel. And for me also, there's a sense of disappointment that South Africa discontinued its applications to the court. So South Africa applied 3 times. And in a sense, this is an innovation when it comes to the Genocide Convention, because the Genocide Convention, we need to remember, is not only about punishing genocide, but the word prevention precedes the word punishment. So it's mostly and firstly about preventing a genocide. And much of the discussions about whether Israel was committing genocide or not, and at least in mainstream Western media, following these court orders, was kind of obscuring this fact and trying to kind of detract or distract from it, because even if we disagree if Israel had committed genocide by that point, the idea was to prevent genocide. And if in January we're told you should stop and prevent genocide, and then 14 months later you are still doing the same kind of action, and throwing people into more desperate conditions in ever-shrinking spaces, and then continue to uphold humanitarian aid and use starvation against them and bomb refugee tents, etc., then obviously the evidence is increasing. And by May, I think the court was already seeing how much evidence there is. The difficulties that some judges said is that for them, this is becoming about the enforcement of our own rulings, and this is not the business of the court to enforce its rulings. Now, seemingly, South Africa stopped after that, after May, going back to the court. So since May, as you know, there was a lot of stuff happening, including and more, it's difficult to say this given the enormity of the crimes we have witnessed, but since October, what we have seen in the north of Gaza is becoming another classical case of genocide. And the fact that South Africa did not pursue another application to the court might be because the South Africa have sensed that the court have reached the limit of what interventions it can make. Because courts ultimately are concerned about showing the limits of their own power. Because the more they wag their finger and the more their orders are not enforced, the more weak they look. But for me, South Africa should have pursued and should have forced the court to face the situation in which they need to kind of pour meaning into this idea of prevention. What is prevention? If we are going to wait till 7 years or 8 years when the court will decide if this is a genocide or not, because the first priority is not to win the case. The first priority is to stop the killing, to stop the destruction, to stop the displacement.
No, that seems like the most powerful thing is that this, and many of us, I think, felt that. I mean, like not legal scholars like yourself, but lay people like us, that the sense that, well, what is the point of deferring judgment on whether or not this is a genocide in technical terms until 2045 or whatever, when it's happening, it seems to be happening right now. And anyway, as you're saying, the point should be surely to prevent it from happening, not after the fact say, oh yeah, by the way, that thing was actually genocide, long after it's too late. But it also raises the question of, well, why did South Africa seem to drop the ball? Why, and not just South Africa, aren't other countries, I thought other countries also signed on, like Namibia and other countries too. So in theory, couldn't they say, well, in the meantime, look, as you're saying, look at North Gaza, where the Israelis themselves are openly using the language of, they're using the word extermination in particular. There's some professor at Tel Aviv University who said this publicly in the context of the so-called generals' plan for North Gaza. We need to exterminate them, basically, is what he said it explicitly. So why has no other country in the meantime stepped up to say, this is it? And also, in the absence of South Africa or some other country taking such an action, can the court itself not issue yet another ruling saying, hey, we said back then this should stop? I remember even in the January ruling, the court said Israel must basically, if you take it apart, it's basically saying you have to adhere to the Genocide Convention. All of the things that it was doing was violating all the steps of the convention. So why is nothing happening? I guess that's the question. Why does it seem to have ground to a halt?
Well, I mean, we can speculate about some of this stuff because we are not, aware of the details of the the South African considerations, nor the internal deliberations on the court. But with respect to the latter point that you mentioned, yes, the court can, on its own initiative, intervene again. So South Africa in February sent a letter to the court asking the court to activate these powers there on its own initiative to intervene in the genocide, and the court declined to do so. They issued a brief statement. So potentially the court, if it wanted, if it was not incapacitated by some disagreement internally or fear for their institutional continuity, they could have activated these powers. They haven't. South Africa itself did not ask them to do so. Now, the different states that intervened, like Colombia and Mexico and Spain, including Palestine, they intervened mostly as through kind of a mechanism that calls an intervention in the construction of or interpretation of a genocide convention. So how to interpret in order to apply the genocide convention in this particular case. So these interventions are not based on kind of a factual or evidential intervention. So the main party is still South Africa. Although State of Palestine potentially could have kind of joined as a kind of party, but for some reason they did not want to join as a party. So the only state that is presenting the evidence and is able to ask for provisional measures for the moment is South Africa, and they have declined to do it more since May. For me, the question is eventually, what is the utility of the Genocide Convention? Is the Genocide Convention some kind of historic document about past events or a handful of couple of events? Or is it, as the title of the convention says, is also about prevention and identifying atrocities as they happen in order to prevent human suffering and the killing of, the mass killing of civilians? So now the court has two cases before it, because so far the ICJ has been very kind of conservative and limited in its application of the convention. And it had two cases regarding the Bosnian genocide. And in these cases, they recognized the, one kind of limited incident or town, Srebrenica in Bosnia, as an account of genocide. We know that in the international criminal institutions, with respect to Rwanda, there's also kind of a recognition of genocide there. But now there are two cases, the question of Myanmar and the question of Gaza or Palestine. So if potentially the court says there's no genocide in Myanmar and there is no genocide in Gaza, if they adhere to a very limited and narrow construction of the Genocide Convention, then we would remain with one case of a small town in Bosnia in over 30 years that is considered a genocide. And if that is the application of the Genocide Convention as far as state responsibility is concerned, like one case since World War II, then obviously that means that the Genocide Convention is next to useless. So one of the interesting things is that the Gaza case is happening after Myanmar, and that exposes the Western states. In Myanmar, these states, there are 6 states, including Canada, the UK, Germany, and France, the Netherlands as well, and Denmark, I think. They made a joint submission in which they argued for a more expansive interpretation and application of the Genocide Convention for the same reason I just outlined, that if you keep it as narrow, as conservative as the court indicated in the Bosnian cases in the 1990s and then the 2007, I think, that will mean that the Genocide Convention, there will be no determinations of genocide in any case. So now that both cases are in front of the court, then we will see how the court handle these cases and what kind of interpretation they choose.
So, Nimer, on this point, we're sort of getting to the conclusion, but of our time here, and we thank you for your time. But given everything you're saying, and given the fact that there's so much up in the air in terms of the long length, the length it's taken to even get to a decision, and that we're not even sure what decision they're going to take, and given all your criticism of law and the people, what is the point of law? I mean, what is the point of all these discussions, and how do you answer the people who say there's simply no point relying on all these cases, all this law, given how, not just how biased it is, but how ineffective it is in actually preventing genocide? So how do you answer, what do you tell people who say, basically, there's no point? It's so fundamentally rigged, there's no point. What do you say?
Well, I mean, it has always, for me, it has always been the case that we need to fight against two extremes. One extreme is the idealization of the law. as if the law is something separate from politics, separate from social and economic influences, as if the law is this kind of moral domain, unaffected and not contaminated by power relations. And at the same time, to fight against the self-defeating cynicism and the dismissive attitude towards the law that eventually leads to quietism and kind of unhelpful politically as well. I think what we need to understand is law, as much as any other social field, is a field of political contestation. And as a field of political contestation, you need, first of all, not to reify it, because there are struggles within that field. There are struggles over interpretation. There are struggles over application. There are, left-wing and right-wing and conservative and progressive kind of legal actors and jurists and theorists in the field of law, as much as in other field that you guys are involved in. So reifying law means that you are abandoning the ability to contest within that field. So you wouldn't do that in history. You wouldn't do that in literature. Why would you do that in law? So, and sometimes I also feel that people, are separating between, admiring someone like Francesca Albanese or Raji Sourani or Blena Negroli, and between law. So they are skeptical about law, but they're admiring these people. But you are admiring these people because they are actors within the human rights discourse. They are actors within the field of law, and we are admiring them because they are mobilizing the law in order to try to bridge the gap between, ideal and reality, between the aspirations and the facts, and in order to force the legal system, whether internationally or domestically, to uphold its own proclaimed principles. When it comes to the critical and radical traditions in law, it has never been the attitude of these activists or lawyers or jurists that you should, not use the law when it is possible to defend the oppressed or the marginalized. It has always been about the attitude that law is the only or the main tool for liberation or for the advancement of rights. So when it comes to demonstrations, this is one tool. Law is another tool. So when you win in the court, you don't go to home and you don't organize another demonstration, but rather you see this law as backing up these demonstrators, as putting wind in their sails and emboldening them in order to tell them that you are vindicated. So again, this is one of the the problems of the poverty of discussions about law, specifically for those of us who spend too much time on social media, is that the reaction to the ICJ advisory opinion in July, which was a huge development and a vindication of the Palestinian and the pro-Palestinian narrative. And then someone would say, well, the judges said what we know. But again, that misses the idea of political contestation, that we are in a field in which we are contesting, and all these things are contested, and there are enemies who are contesting. So when you are vindicated, when you are emboldened and supported, and there is something additional that can support you, and from the legal field as well, then you should seize it and take it and use it. As I said when we talked about the ICJ case, look, our political and moral judgment is not reducible to the legal. So there's a lot of literature in criticism of the ICJ decisions with respect to Bosnia. Ruthless criticism. And courts, as we know from domestic legal system as well as the international legal system, can err. They might make mistakes. So we always reserve our judgment, because our judgment is not only about the legal. So the Iraq war, for example, was illegal. The sanctions in the 10 years that preceded the war against Iraq, that killed at least 500,000 Iraqi babies, was legal. Does that mean that I oppose only the war in Iraq? No, I also oppose the sanctions because I think they were inhumane, politically and morally objectionable. So the first thing that we need to realize is that we still have a judgment about these rulings when the law is consistent with justice, with morality. Then we support it, and when it falls short of the demands of justice, we try to mobilize in order to bridge the gap between law and justice. And I think this is our duty as kind of activists and human rights lawyers or persons of conscience who are kind of acting in a very difficult field, specifically if you are in North America, I guess, but also in Europe, in which there are also such hostility and organized forces. And then you get the ICJ to say what these students were reprimanded for, right? And the media has been attacking academics who said these things. So I think it's important to realize the potential, but also the limitations of what the law can contribute in particular situations, but also in the kind of longer trajectory. The criticism of the Palestinian authorities' approach to the law has been in previous years is that they first of all, they don't have a political vision. And the absence of a political vision means necessarily that most of these legal victories, no matter how limited they are, such as the ICC arrest warrants, will be not as effective as they could be in order to contribute to kind of a progressive movement towards.
But Nimer, sorry, to come back to the arena that we're also invested in here, which is the international arena over the legitimacy or illegitimacy of Israel's actions in general and its political system, the apartheid, and so on. No matter what happens in a way with the ICC or ICJ cases, or building on the ICJ advisory opinion about the illegality of Israel's occupation from July this past summer, doesn't it matter, just in terms of the struggle over legitimacy, doesn't it matter that there are in fact arrest warrants issued for these two people? Doesn't it matter that the ICJ has repeatedly warned about the very real possibility of the threat of genocide in Gaza? In other words, don't those legal actions, even if they don't go to any actual legal consequences per se, I think part of what you're saying is that they still have a political impact, in the sense that people like us, they look at what's happening, look at what the legal system says, in the same way that we can draw on international humanitarian law in general and talk about Israel's violations of the law, right? Doesn't it help, in other words, even if you see what I'm saying? Does it make a difference?
Yeah, obviously. I mean, I think this was my answer to Osama earlier when he said, why do you say it's an earthquake? And I said exactly what you said, is that there is kind of an added value of having these arrest warrants, even if, at least in the short term, we don't see efficacy in terms of the enforcement. And also, there's an element of unpredictability, in politics and law. So who knows what are the ripple effects of current events and how these kind of tools can be used. Pinochet and the whole saga around him eventually emerged because one judge decided to do something about it in Spain, and then we had that case. So again, I think, as you said, we need to recognize the importance of these events. In terms of obligations now on different states, corporations, academic institutions, we have now 3 legal kind of documents. One of them is the 3 provisional measures by the ICJ on the question of genocide. The ICJ ruling in July, which says BDS, it says sanctions and boycott. So this is very important now. When people are being branded for anti-Semitic and all these kind of ridiculous and laughable accusations. And then thirdly, the arrest warrants. So it's not only about the legitimacy of Israel's actions, it's the legitimacy of Israel as a state. When now Amnesty International is coming with a 300-page report, Genocide, and a couple of years ago they came out with another 300 or so page report on apartheid. That's a very different landscape than 1980s or the 1970s, and how Israel was received after the 1967 war.
Nimer, just a final question from me. I mean, we're seeing, I think you just laid out what I was going to ask you. So this idea of, on the one hand, these extraordinary cases, the ICJ case in the summer on the illegality of the occupied lands, the ICC case that's ongoing, and the genocide case which is ongoing. I don't know if there's other stuff, but at least these three kind of major cases that are right now. And on the other hand, and more attempts at national courts, at least in Europe and other places, to potentially start investigating or arresting people that are involved in these kinds of cases. On the other hand, we see that since, and you mentioned that the South Africans, as of I think May or June, kind of stopped going back to the court to get other decisions being made, or temporary decisions. We see this incredible shift by the Israelis with the Americans to go on full-on attack. So we see now, to go back to the original thing, you see Syria, they've increased, they've broken, and they said, Netanyahu sort of hinted that the 1974 disengagement line is now, as far as they're concerned, null and void. We've seen in Lebanon that they've come in and they're using self-defense, but I think you said at the very beginning, all these questions of self-defense is nonsensical over such a long period of time, and they define it as they wish. So you see it in Syria, you see it in Lebanon, and obviously you see it in Gaza and the West Bank, and very likely the West Bank situation is going to get worse in the coming months as Trump and others kind of come into office. So you see, on the one hand, all of this, all the legal cases being built up, and on the other hand, you see a very in-your-face breaking of international law with the nominal backers normally in the liberal kind of order, and the Europeans and the Americans, basically accepting one way or the other, kind of accepting what the Israelis have been doing and giving them carte blanche. And this can go on for another months and I don't know how long. So how do you, it's a struggle. Obviously, you said it. It's all about this kind of struggle, but it seems so stark, much starker than it was before, where in the 70s and 80s and maybe even early 90s, and the Israelis would break the law, they would say that, maybe the US might say that, but in general, most would say, no, this is breaking the law. Now you have the major powers saying, oh, no, it's okay, you can break the law, that's fine.
Yeah, but as we have established that this situation is a bit different, because now you have the ICJ, both in the genocide case and the legality of occupation case, and the ICC and the arrest warrants are telling these Western powers that, this is the situation, and their brazen support is no longer only directed against, the rest of us in the global South and the victims of Israel's aggression. They are also undermining the whole edifice of the post-World War II international order that they themselves have been telling us is the achievement of humanity, and it's the sign of the progress in human history and all that kind of idealization. I think one of the important things to remember now, to kind of watch now, is obviously Trump will pursue policies to try to kind of approve of Israel's actions, like he did with respect to the Golan Heights and the Western and Morocco's occupation of the Western Sahara in his first administration. So we might see moves like that with respect to Gaza, or with respect to further to the Area C in the West Bank, maybe even some Syrian territory. So what's important is what follows, like what is the response? One of the reasons why, we Palestinians and legal scholars in particular are against the 242 UN Security Council resolution is because it's sanctioned in the sense of approved and legitimated previous Israeli acquisition of territory, including demilitarized zones that they seized from that was near Egypt and near Syria after 1948. So it's not only that Israel acquired by force more territory than they were assigned in 181, the UN resolution, but also they seized the demilitarized zones. And then 242 basically kind of permitted and put a legal kind of imprimatur on all these kind of acquisitions. And then we start over since 1967. So hopefully the decisions by these courts and the contradictions that the brazen Western support, at least in the mainstream media and the mainstream academic institution and the mainstream formal decision-making powers will create enough contradictions in the system to allow for an alternative. I think if you look very carefully about what has been happening, it exposes the limits of the so-called democracy in Western countries. Because one, when you have hundreds of thousands of people, week after week in London and other capitals who say that we are against the war and we want ceasefire, and when you see the majority in public opinion polls, even in places like Germany or the US, that say they are for ceasefire, and then that is not translated into official decision making. This means that the so-called constitutional democracy in the West have isolated themselves successfully from the pressure of the public, from representing popular majorities, and that's a democratic deficit. And secondly, when the media is also not reflecting popular sentiment, that also speaks to the corporate control of this media. So we need to also in the so-called Western societies, we need to think about democratizing the political system. We need to talk about democratizing the media because they are unfit for purpose. And obviously, when you see things like the total support in the media, the kind of a propaganda, and one leader in the West after another supporting the hooligans of Maccabi Tel Aviv in Amsterdam, that will only lead to a ridicule and lack of confidence in kind of mainstream media and the mainstream leaders within these Western societies, because everyone can see that the reality was the opposite. And obviously, when it comes to Israel, for decades to come, all of at least the kind of younger and the middle-aged generations will associate Israel with brutality and atrocities for the near future, because that's what they have witnessed and seen for a long time. And some of these people will be power holders or kind of public opinion makers in the future. So it's fine to say that we kind of have a sober analysis and see the challenges that are coming ahead, specifically with the Trump administration in power in a month or so from now. But that only should lead us to kind of find the strength, help each other, coordinate, and try to fight back. And that's also, again, one of the important kind of effects of having an Amnesty Genocide report, the ICC and the ICJ ruling, because this help us to have a baseline and opens up the legal and the political space for others to have the courage and to make these determinations and to hide, if you want, behind these reports by citing them and using them for the coming battle over genocide denial. Because the fact that this is a Western genocide and the fact all these academic institutions, corporations, media, and power holders in Western governments have been complicit will obviously incentivize them to deny the genocide. They have no incentive to admit the genocide, because this will mean admitting that they were complicit in it, that they were cheerleaders of this genocide, they funded it, supported it politically, and so on and so forth. So we have a kind of a big challenge, and I look forward to more kind of prominent organizations like Amnesty releasing these reports, because that will only help us to do more and to support the students and others who want also to do that kind of work in an increasingly challenging environment.
Nimer Sultany, on that note of hope and optimism and realism.
The pessimism of the mind and the optimism of the will.
The will, exactly. Well, thank you very much for all your insights, for sharing your extraordinary knowledge with us. And, we look forward to seeing the gap between law and the application of law narrow further, especially in the question of Palestine. Thank you, Nimer.
Thank you very much for having me.
Thank you.
Thank you all.
All right, guys, we just had this extraordinary discussion with Nimer Sultany. It was quite detailed and dense, obviously, because he's a profound scholar and there's a lot to take in. But very briefly, Karim, what did you think about that discussion, about the gap between law and the idealization of law on the one hand and the reality.
Yes, well, I mean the idea of law as a sort of politics, right? As a side of struggle, it's politics. I mean, it's interesting the way he put it that, for a lot of people who celebrate somebody like Francesca Albanese, on the other hand, are cynical about the law. I mean, when she's basically just trying to use the law to get somewhere. So there is this thing, I think, in all of us where we all see law, we want to push it, and we want to push for justice and push for the right thing. On the other hand, there's a part of us that just sees the realpolitik and sees this incredible brute force and power supported by the superpower, basically, negating all of these kinds of laws de facto and saying, well, it's you can't catch us, so we can do what we want. So this kind of going back and forth, I think, is the case for most of us. You go up and you go down, you go up and you go down, depending on the moment. But what I would just say is just a reminder that you've got these three extraordinary cases going on: the ICC, the ICJ case that was decided in July on the occupied territory, and that Nimer didn't have a chance to kind of go into the details. And then, of course, the genocide case. So you've got these cases going on, all on the question of Palestine, in addition to other cases and sort of historically that have taken place. And so I find that there's this kind of proliferation of international court cases and also national court cases that are going to take place. And at the same time, as I said, we've got this kind of cynicism of what law is when you see the Israelis invading all the countries and committing genocide, and I shouldn't say all Europeans, but sort of key European states like the Germans, the French, and others sort of basically saying it's okay, and the Brits. Although you have other countries like Spain and Norway and others that have been quite good. And then you see the Israelis saying, declaring the UN Secretary General's persona non grata. They're saying we can get rid of the entire UN building. It's really, and calling the Secretary General an anti-Semite. I mean, it is pretty incredible.
Brazen hypocrisy. Sadi, what do you think of that discussion, and also the idea of the utility, the criticism of the utility of international law versus the political effects and narrative and legitimacy questions?
I mean, I think that's what came up at the end. I think those things are very important. As Karim was just saying, I mean, no matter where these cases go in technical legal terms, the fact that they're out there, and once they issue their findings, as the ICJ did in July, for example, not just on the question of occupation, on the whole question of apartheid too, and hence the need to boycott and so forth. That's a massive shot in the arm for anybody protesting against Israeli apartheid and genocide and so on and so forth. The amnesty report, all of these things lend assistance to. They help to delegitimize the Zionist project in Palestine, which is premised just from the beginning and always has been on apartheid and genocide, and obviously it helps boost the fortunes of those who are trying to say we are up against an essentially politically illegitimate project of dispossession, violence, home demolition, apartheid, and genocide,
racism, so on,
and everything else. Yeah,
but also
but then the question is,
but also individuals. The idea is that a lot of these people will not be able to travel to many countries, not just Netanyahu and Gallant, but others who are going to be scared to be indicted in national courts.
Karim, on the basis of the ICC, on the basis of the ICC, or both the ICJ and the ICC?
The ICC, I mean, in terms of who they may add to the list of people they're issuing warrants for, but in national courts in Europe, for example, especially as Nimer mentioned, if they're if they're dual citizens.
Fair enough. But what Nimer said, I seem to understand what Nimer was saying at the end. The conclusion of what he was saying is that basically the Western powers are willing to sacrifice. It's not. He said from the beginning that there's always been.
Well, it's a test.
It's the question. It's the question.
This is the test. If, for example, let's say Netanyahu is trying to get to the U.S., his safe haven, and his plane has engine problems and he's forced to divert to Brussels, for instance, right? That's going to be a test. Will the Belgian authorities arrest him or not? And
I understand the point, but I was making the point I was trying to say is that he was saying from the beginning, everyone who listens to this podcast and watches this podcast will know, of course, that the hypocrisy and the lack of enforcement and so on and so forth. Those have always been an essential part of the application of law, or the lack of application of law. But what he was saying, I seem to understand him to be saying, is that the West in its support for Israel, is willing to demolish the very structures of Western liberalism. That was the point you were raising at the end. The Israelis are brazen in their violations.
It's the point we were making. Yeah, absolutely.
Repeat. Look at our universities, Osama. Our universities in
That's what I'm
Western
saying.
states have become armed camps, basically, where riot police patrol us, and everybody's muzzled, basically, not to protect American or European states.
Not that would be good, frankly. Not that would be good if it was.
No, I know, but that's not. But the point is, it's to protect what's unprecedented is that the West is willing to destroy its own civic institutions in order to protect the interest of a whole
and liberal order and the international liberal order.
And the whole. That's what I'm saying.
It's happening simultaneously.
Yeah, absolutely.
Yeah, but can we just end on this point, Karim? Can you just clarify just the last point? I'm trying to understand. How is this an ending of the liberal order if the liberal order has always had this massive racism and contradiction built in from the beginning?
Because it's never been brought to the test in this way. So that's what's different. These things are
structural.
The test.
I mean, it's structural. You set up the ICC, and then you say this is for everybody. Then you bring in these various African and kind of non-white kinds of people, and you put them in. People say there's double standards, but you're going through that kind of procedure. Now you're in a situation where they don't even bother anymore. It's direct. It's in your face.
I see. Yeah.
And there's not even a pretense. Not even the discourse, the language. They're not even trying anymore. And so that puts the hypocrisy. It's no longer hypocrisy. It moves to. It's not even. I mean, I don't even think of it particularly anymore as double standards. It's removing even what they had put in place. And this is a test case. And Palestine, as usual, just as it was when the UN was created originally. From the very beginnings, all these UN agencies, peacekeeping, all this stuff kind of comes about because of the question of Palestine. Now you have this thing falling apart here as well. So we'll see how this develops.
Okay. On that note, guys, it was great to see you again.
Great.